All right, good afternoon, everybody. My name is Andrew Schaefer from Trafalgar. I'm based in Trafalgar's Johannesburg office near Sandton and Melrose Arch. And I'd like to welcome you to the second webinar in our 2023 series. The topic you see on the screen is a very important one, amending the conduct rules and enforcing conduct rules, which is all important in terms of harmonious living in community schemes. Just a few housekeeping points before I introduce our guest speakers this evening. We'll make a prompt start now at 5, and we aim to finish promptly at 6 p.m. The webinar is being recorded, and a recording will be posted on our training website, which is training.trafalgar.coza. That will be by Wednesday next week. And on the same training website, you'll find a host of free e-learning training covering all aspects of community schemes, training for trustees, training for residents, and training on a variety of related topics. Also, all the recorded webinars we've done over the last few years. So you can have a look for that. Also posted there will be our webinar last month, which was well attended. That was solar installations for community schemes. My colleague Karine and I will endeavour to answer questions as we go through the webinar. We'll do our best to keep up. Those questions that we can't finish or complete, our contact details will be provided at the end of the webinar. You are welcome to contact us and we'll endeavour to get back to you right away. And we are open to any contacts ahead in terms of questions, queries, or support about amending conduct rules and how to go about getting those approved. So that offer remains. Our next webinar is also advertised at the end. That will be on the third Thursday of every month. So the Thursday, the 20th of April at 5 p.m., we'll be offering a webinar on arrear levy collections. And those details will be shown on the last slide. And we will also send out an invitation to those who are registered for this particular webinar. So please be aware of that. At the end of the webinar, there will be a questionnaire that pops up from the Zoom platform. If you would like to answer that, we'd appreciate it. It's just a few short questions on how we could improve these webinars to be more useful, more practical. Any ideas about other topics that you would like us to cover, and any better times that you would like to recommend. Although we have researched it, and the third Thursday at 5 o'clock does seem to be a compromise between work and personal time and fitting into busy timetables. But by all means, the questionnaire feedback would help us test for better timing. I'd like to introduce our guest speaker this evening, who is Zelinda van der Merwe. Zelinda, welcome. Thank you very much for joining us on this webinar. I'd just like to introduce Zelinda to our guests this evening. So Zelinda was literally born to be a sectional title and community scheme specialist. Zelinda completed a master's in law degree at the University of Stellenbosch. Her thesis was on the constitutionality of sectional title rules. So we have a guest speaker tonight who has a master's degree and did her thesis on a topic related exactly to what we're going to talk about this evening. Zelinda's also worked as a research intern looking into property law. After graduating from Stellenbosch, Zelinda has actually worked as a portfolio manager, managing a portfolio of sectional title schemes and homeowners associations, and so has direct practical experience in terms of, what goes into managing a scheme, working with trustees and directors, and many of the practical challenges that arise from that. Zelinda has now opened a consultancy based in Cape Town, specializing in sectional title and community scheme advisory work. And I think Zelinda will refer to some of the work they're doing in terms of updating conduct rules, advising on conduct rule disputes, and other support services they provide with legal in community scheme circumstances. I'd like to introduce my colleague, Karine Coetzee, who will assist me with the facilitation of questions and the presentation. Karine has over 20 years experience as Trafalgar's property management consultant. She provides support to all of our portfolio teams in terms of legal questions and other operational queries. And so Karine is very well positioned to assist with answering questions. and Karine will actually kick off the webinar this evening, just to give us an overview of exactly how do you go about amending the rules from a practical and a resolution point of view. So Karine, if I may hand over to you then to start us off this evening, and from your slides we'll move on to Zelinda directly. So thank you everyone, welcome, and over to Karine.
Thank you, thanks Andrew, thanks for the opportunity. So basically, I just want to run through in terms of sectional title schemes, as that is our main focus. I will touch on HOAs as well, but our main focus is sectional title schemes. All sectional title schemes basically have two sets of rules, the one being management rules and the one being conduct rules. By default, all schemes have these two sets of rules. Annexure 1 to the Sectional Title Schemes Management Act is the prescribed management rules. That is the default management rules that all schemes uses. And then Annexure 2 of the Sectional Title Schemes Management Act is the prescribed conduct rules. So if you do not amend your rules, if you do not customize your rules, do not worry, you still have rules. The prescribed rules will apply. It is also possible to amend these rules, both the management rules and the conduct rules. In order to amend the management rules, you will need a unanimous resolution. And in order to amend the conduct rules, you will need a special resolution. So not going to a lot of detail as to what a unanimous and a special resolution is. We have available an easy guide to resolutions. If you pop me an email, my email address will be at the end of the webinar. I can send you our easy guide to resolutions. But what it boils down to is that you need a certain percentage of owners to vote in favor of these rules before they can be amended. For unanimous, more difficult, you need all owners to agree. For special, you need 75% if it is at a meeting. So basically, you need to, as I said, it is possible to amend your rules. It can be done. For a homeowners association, you will need to check your MOI if it's a company, or your constitution if it's a common law association, to see who can make rules for the HOA. Normally, it stipulates that the trustees or directors can make rules. It can also stipulate that the owners, by virtue of a special resolution, for instance, can make rules, but that will depend on the MOI or constitution of your specific homeowners association. And yeah, they all differ. We also have on our learning platform, as Andrew mentioned, we've got a training page on our website. On there, we've got an introduction to HOA course that is available for our HOA listeners. But as I said, we will be mostly focusing on sectional title schemes this evening. Thank you, Andrew.
Great, thank you so much. Oops, yeah, I see Andrew's still muted.
Yes. I was just about to thank Karine and to ask you to go ahead. So thank you, Zelinda.
Fantastic, thanks so much. I've tried to share my video, but unfortunately I'm not able to start it. I've got the lovely Trafalgar background behind me that I'd also like to show off. So if you can allow that in the background, that'll be great. But if not, it's also all right. So firstly, thank you so much to you and Karine, Andrew, for allowing me the opportunity to speak to your listeners this evening. I'm having a keen look at that participants list, and it is increasing literally by the second, which is absolutely amazing. You've got such a great audience for this topic. It is a very useful topic, and it's something that we deal with on a day-to-day basis. You could say that it's the bread and butter of our consultancy. And as you mentioned, I did my master's in the constitutionality of rules. It was under the old act at the time, a little bit more boring than what we have today, but it's something that we thoroughly enjoy doing. Let's see if I can share my video now. There we go. Awesome. Karine, I'm not too sure if you're monitoring the slides. You're more than welcome to pop off to the next one. There was a question that was asked about how often the rules should be amended, and Andrew, you kindly answered that there. We were taught at Paddock's, Prof. Paddock always used to say that a two-year turnaround time was a good average on the change of occupation and ownership in a scheme. I'm sure that you and your team can advise a lot more clarity, with a lot more clarity or confirmation, how often schemes have units that change hands or occupiers that come and go. But it really does depend, as you've answered, on the practical requirements of the scheme. What is needed, when it is needed, what is problematic. it was very interesting to see during the COVID time what rules actually became quite relevant and which rules suddenly didn't become really that important anymore. So a lot of people working from home, they suddenly had issues with noise, kids, doing schooling at home, barking dogs. Everybody wanted to suddenly keep a pet or a cat because they were at home and they could care for the animals. So the keeping of pets became a very big thing. People started looking around the common property, what was needed, and those rules became very important. So it is important to ensure that the rules suit the specific requirements of the scheme, the nature of the scheme. Is it a residential, a commercial, a mixed use? Is it a body corporate within a homeowners association? Is it bound to the provisions of the Constitution or the Memorandum of Incorporation? These are all things that we need to look at. It also needs to be in line with the ever-changing practice directives of the Community Scheme Ombuds Service. I know that Karine always has her finger on the pulse when it comes to anything CSOS related, and Trafalgar and Karine's office is one of the first to know the changes that the practice directives introduce. We attended a very useful webinar earlier today with Marina of BBM, where she spoke about the proposed changes to the Sectional Title Schemes Management Act and the Community Schemes Ombuds Service Act, and how that is going to affect the rules in our body corporates as well. So very, very interesting times that we have. It's very important to remember that the management rules and conduct rules of your body corporates are only enforceable if they have been registered with the Deeds Office prior to the 7th of October 2016, and of course registered for approval and review by the Community Scheme Ombuds Service post the 7th of October 2016. We do have an example of a certificate of approval that we'll show you, and only when you have that certificate of approval from that date does the rules actually become enforceable. There was another question on the platform as to consolidation of rules. It's very important to know that your rules have to be in its consolidated form. That does not mean conduct and management rules together. It rather means every single amendment to the conduct and management rules have to be kept together in one document. So one for conduct rules, one for management rules. And as those amendments are done over time, you don't have random rules floating around. It is in a consolidated form, and that is what is submitted to the Community Scheme Ombuds Service. So we can pop on to the next one. So some of the examples of rules that have been affected by practice directives, by the Community Scheme Ombuds Service, by the Sectional Title Schemes Management Act. Interestingly, the conduct rules are a lot shorter than what they used to be. Our version of rules that we prepare tend to be on a little bit of the longer side. Our motto is better to have it and not need it than to need it and not have it. But we are happy to work with our trustees what is going to be practically achievable and suitable for the needs of the scheme. So some of the things that we can't have anymore, and there's a lot of information out there as to what is deemed to be desirable or undesirable rules of the Community Scheme Ombuds Service. Towing, you can't have that in your rules if you're a body corporate. If you're going to have such things as wheel clamping, there needs to be release fees or fines payable. You need to have an internal review or internal dispute resolution process, but you can't provide for arbitration. You need to make sure that you either allow animals or don't allow animals. You can't be discriminatory, and you have to allow guide, hearing, or assistance dogs. And we can have an entire webinar just on the concept of a guide, hearing, or assistance dog. So we won't get too into that unless there are some questions. You have to deal with the recovery of legal fees that needs to be in the management rules. It's something that is very difficult to pass by the Community Scheme Ombuds Service. Fines, that's a big one, and we're going to talk about that a bit more under the enforcement of rules, dealing with interest, and then some of the practical requirements under the Sectional Title Schemes Management Act. There needs to be an index, there needs to be a take note clause, which basically emphasizes any rules that deal with exclusive use areas, maintenance, financial obligations. And then, of course, there can't be any reference to the Sectional Titles Act because the rules are amended under the Sectional Title Schemes Management Act. All right, we can pop off to the next one. So why approach somebody like TVDM Consultants or any one of my incredibly knowledgeable, well-known colleagues in the industry, or even ask your managing agents, such as Karina Trafalgar's offices, to assist in this exercise? It is quite a project. It's most certainly one that doesn't happen overnight. I must say that your offices, Andrew and Karina, are one of the few managing agents that we've worked with that has embarked upon such a massive, large-scale project to ensure ensure that all the body corporates are compliant with regards to rules. It is something that unfortunately only gets done once a problem arises, and not necessarily something that is done to avoid issues. But when you engage with a specialist, you're engaging with somebody that has practical experience, and not necessarily in how it works in your scheme, but how it works in the sectional title space or the homeowners association space or share block or retirement scheme, whatever the community scheme might be. In our experience, we actually have both the legal as well as the practical experience, having been managing agents ourselves, having worked with the community scheme ombud service, and being really involved in the process of the practice directives and the provisions of the legislation and amendments thereto. Of course, you need somebody that knows the legislation. It's pointless going through a 6-month exercise, or shorter or longer, and then simply having the community scheme ombud service not approve the rules because it doesn't comply with legislation. And then, of course, one needs to ensure that the constitution of the country is upheld, so rights to privacy and all those fun things. Reducing, of course, the need for any type of rules that's going to cause a lot of hard work for the trustees if there isn't anybody on site. It's all good and well to have all sorts of enforcement mechanisms in place, but if you don't have somebody on site to actually enforce the rules, or a willing and able person, it's really no point in having it. So that's something to look at as well. We can jump off to the next one. So our process, what we do, and I think this is quite nice, we offer a set process to assist body corporates in the amendments of the rules. It's a set process, set fee, so you know what you're getting yourself into, for lack of a better word. We don't believe in template rules. Each scheme is different, each person is different, each committee is different. So we do like to engage with the trustees and sometimes even owners up front to get a better understanding of what the scheme is all about. We do this all over Zoom, so it's more accessible for people, but we do like to see your current rules and your sectional plans. And of course, the big one, solar, we have been getting quite a few requests to actually prepare conduct rules dealing with creation and allocation of exclusive use areas for solar installation, and then the conditions relating to it. But you guys did have a very big webinar on that not too long ago, so we won't deal with that too much. Okay, we can move on to the next one. The turnaround time to amend rules, it really is going to be dependent on how quickly you're able to do it within your body corporate. Normally, it is something that is proposed by a trustee committee, sometimes even a trustee or two that might have the portfolio of dealing with legal or compliance or governance or whatever it might be. And then, of course, the owners may direct the trustees at an annual general meeting to deal with the rules, or it could be part of an adjudication order that you need to work on your rules, or owners representing 25% or more of the participation quota of the scheme could also call a special general meeting for the proposed amendment to the rules. Of course, it is better that this project is undertaken by the trustees with assistance with their managing agent or building supervisor or whoever the person might be in that role, that actually deals with the day-to-day enforcement and application of the rules, and to ensure that the correct rules are going to be in place for the body corporate. So in our process, we try to work on about a 1 to 2 week turnaround time after we get the instruction. We try to meet with the trustees as quickly as possible, strike while the iron is hot and all those fun things, give the trustees an opportunity to have a look at the first draft of the rules and then meet with them thereafter. So again, depends on how quickly they can deal with it. My memory fades quite quickly, so I always like to work on something relatively quickly after a consultation, or deal with the second consultation quite quickly. Once the rules have been approved by the trustees, or the trustees are happy with it, we always do suggest that there is some form of owner engagement, either on an informal route, just sending it to them for comments or queries, involving them in a committee, for example, alternatively sending it directly out as part of the formal notice. The notice does need to be called either for an annual general meeting with special business or a special general meeting, 30 days notice because it's special business. And then the archaic method of delivery of prepaid registered mail or hand delivery and email. Just a reminder, because you need a special resolution for conduct rules and unanimous resolution for management rules, you cannot just send the notice out via email. You can call it on a shorter notice period, 7 days by trustee resolution for urgency, or I can't really imagine what could be urgent unless you have an adjudication order directing you to do this within a certain time period. Alternatively, if all the owners agree to waive the notice for the meeting, which I haven't seen in practice just yet. Once it has been approved at the member meeting, AGM or special general meeting, it must be submitted to the CSOS within 10 days of that special unanimous resolution being passed, bearing in mind that if you've got a quorum of less than 50%, although it's legal to go ahead with the special resolution, if you have a quorum of less than 50%, you have to wait 7 days. I like to call it a cooling off period to allow any group of owners representing 25% of the participation quota to call a meeting to deal with the resolution again. So it needs to go to CSOS, and then we look at a timeline for the CSOS. We can go to the next slide. While we're doing that, the CSOS timelines are 30 days for new schemes. In other words, rules that are submitted by the developer or the developer's conveyancer. There is quite a serious repercussion for those rules not being done in time for a new development, and anything from 30 days to 60 days for an existing scheme. The CSOS processes have exponentially improved over time. Their timelines have gotten a lot better. We know who to deal with when we're dealing with them, and you have direct contact with the relevant person as well. They're quite good with acknowledgements and advising you who the contact person is, giving you a reference number, so you are able to follow up. Again, the process and the project of rule amendment is not really something that is done on an urgent basis, but it is possible that it is part of an adjudication order, or perhaps there's exclusive use areas that have been created, or solar panel installation, so there might be a reason for it. So how to create awareness of the rules? It is very important to remember that it is actually the body corporate's responsibility to ensure that any owner, new owner, or occupier, so a tenant or anybody that is staying within a unit in a body corporate, to actually be given a copy of the rules. It is not the owner's responsibility to make sure that they go and ask for it. But of course, if you do require records of the body corporates, including rules, you may request it with a written notice to the managing agent or the trustees. And in the case of rules, they've got 5 days to make that available to you for inspection and copies, and can charge you a fee for the copies. What we do like to suggest is that when there are not owner occupiers or short-term tenants, that the rules are made available to everybody, made visible at least, perhaps putting an abridged copy in the elevator or in the foyer or at the entrance, making copies available at the security or the concierge, however your setup might be. And then very, very important with rules, nobody really knows that the body corporate has rules until they receive a fine on their levy accounts, and then suddenly they start asking for a copy of the rules. So it is important for everybody to be aware that every single body corporate does have a set of rules. If you don't have the amended conduct or management rules, the prescribed management and conduct rules will apply to you. Okay, we can go on to the next one. All right, so some of the tips that we can include in your conduct rules without taking you through our, I think it's a 36-page document at the most extreme. Our rules have been with annexures and all those fun things. Just a couple of the tips that we can share with you for drafting of your own rules. It's not impossible for trustees to prepare your own rules. And of course, if you do have trustees that are available, that have the time, that have some experience on other committees, not necessarily having to have a legal degree, but most certainly some experience would be very useful. A good place to start is the prescribed conduct rules, noting that the prescribed conduct rules are quite shortened to what they used to be. So you need to understand that in the normal course, the prescribed conduct rules are not going to be sufficient for a scheme, but it is a good place to start. As well as the practice directives of the Community Scheme Ombud Service, you need to look at what they consider to be desirable or undesirable rules, and what type of rules you actually have to have in your document. So you have to have some type of provision for slaughtering for cultural and religious purposes, or you cannot prohibit it within the scheme. So that is something to look at. And then, of course, we mentioned earlier, you can't have undesirable rules like towing. In the case of fines, which I mentioned we'll touch on towards the end, the fine amount is governed, the fining process is governed. So it's important to understand all these requirements of the Community Scheme Ombud Service, because again, if you go through all the hard work of getting the rules tabled and approved by your members and you don't get them approved at CSOS, it is going to be quite a pity. So you have to look at the specifics of your scheme. I like to say to trustees, and I take this advice myself in my role as a trustee, is that I make a note as and when the requirement for an amended or a new rule comes about. So it's a working document, I like to call a set of conduct rules specifically, management rules to a lesser extent, but conduct rules. And whenever a situation arises that the rules don't deal with clearly or don't deal with it all, make a note of it. Or whenever the managing agent draws something to your attention, or the building manager draws something to your attention, or you just deal with an application or a contravention that you haven't had experience with, those are the things to note. Invite your owners to provide comments as to what they want in their rules as well. And like I said, as your ownership and occupation changes, of course, the realities and the needs of the scheme are going to change as well. All right, we can go to the next one. Okay, so some of the rules that we look at, and some of the ones that are becoming quite popular, I mentioned earlier, the working from home, the ability to work from home, noise disturbances, keeping of pets, conditions surrounding keeping of pets, applications for that. The solar one is a really hot one at the moment as well, which can be done either in the rules, alternatively in lease agreements. Then we've got renovations and alterations is always a big one. I'm a firm believer in having an application form that you have the owner actually sign acknowledging and accepting those rules, even though they're statutorily and legally binding on them. You're able to turn around and say, is this your signature on this application form? You've agreed that you're going to do X, Y, and Z. Any installations within the scheme, also a very important one. You don't want to deal with the very first application for an air conditioning unit and suddenly you have to thumb suck, where's it going to go and what's the conditions? So cater for any installations you might not have, but potentially could have in the future. Behavior is a very big one. I mean, that's the whole point of conduct. We like to split our rules into behavior within sections, behavior within the scheme, and behavior on common property, because it's all different. And then you don't need to jump around your rules to try to look for any conduct breaches. It's all in one place. We also like our rules to follow a logical sequence that will assist the trustees in enforcing it. And something I learned from my very first experience with the Community Scheme Ombuds Service is to actually ensure that you don't have references to finding throughout the document per rule, but rather right at the end of the document. And if you're going to refer to annexures or attach annexures, that they need to be clear, they need to be referenced in the rules, and of course they mustn't get lost in the process of getting it tabled for approval with your members and submitted to the Community Scheme Ombuds Service. Let's look at things such as vehicles and parking. That's one of the 3 Ps in sectional title, the parking issue. So that is most certainly something that you need to cater for in your scheme. Exclusive use areas, lease agreements, parkings that are visitors parking bays and how you control that. Wheel clamping we spoke about, but not towing. Short-term letting is another big one that we experience a lot in Cape Town. And then the exclusive use areas creation. Remember, if you don't have exclusive use areas in your conduct or management rules and they don't reflect on the sectional plan, then the exclusive use areas do not exist. They would be de facto. In other words, it's used as though it is an exclusive use area, but it is not. Fining rules. All right, so this is a biggie. I really don't think your rules are worth the paper that it's written on if it doesn't have a fining rule. And I can honestly say in the hundreds of sets of rules that I've prepared over the years, I've only ever dealt with one body corporate that specifically did not want a fining rule. And they were a retirement scheme. So I think they had a pretty good reason to not have a fining rule. Most body corporates do have a fining rule for enforcement. And when I did my master's, I learned that the sectional title legislation in South Africa is known as a toothless piece of legislation. So there's very little you can do to enforce it. And fining is one of those things that you are permitted to do. So when you're dealing with the contents of the fining rule, we're going to share an example with you. So I think we can move on from this slide. All right, we spoke about the undesirable rules earlier, so I'm not going to touch on that any further. Sorry, I jumped a slide ahead. Okay, and then the examples of the undesirable rules, we spoke about the towing, allowing for or requiring registration of a domestic worker, for example, or allowing a domestic worker to walk around wearing a certain type of identity. You see it a lot in homeowners associations where, they need to wear their identity card or a bib or something along those lines. Those are things that are not permitted. If you are dealing with Arbitration, you can't have that in your rules anymore, and we know that that's been repealed from the Sectional Titles Act. Disconnection of services is quite a big one. You can't do that. You can only do that through courts. It is something that the Community Scheme Ombuds Service deals with on an urgent basis if your services have been disconnected. Another one that we see very often is the body corporate attempting to become involved in the vetoing and eviction or termination of lease agreements. That's a big no-no. And preferred service providers, again, accredited estate agents, those types of fun things are not allowed. And then the recovery of legal fees I mentioned earlier is something the CSOS does not like to have in rules, but most certainly can be put in the management rules as it used to be under the old Act. Okay. Enforcement of rules. So this is the last piece that I'd like to chat about, and I suppose it's the most important, because what's the point of having this beautiful document of rules if we don't know how to enforce it, or we are not able to because we don't have anybody on site? So firstly, you have to have a properly member approved, and if it's after the 7th of October 2016 when your rules have been amended, CSOS reviewed and approved set of rules. Very, very important. We very often come across documents called house rules. So that is a little document that says no smoking on common property, you know, no feeding the pigeons, that type of thing, but it's not registered anywhere. So your conduct rules have to be at the deeds office if it was prior 7th of October 2016, or at the Community Scheme Ombuds Service with the certificate of approval if it is post the 7th of October 2016. I mentioned earlier the rules have to be consolidated. So you can't have a document with rule 1 to 13 and another document with 14 and 15 and another document with 16 through 19. It all has to be in one consolidated document for the conduct rules, for the management rules, if of course they are amended. The Community Scheme Ombuds Service wants a copy of the signed minutes of the special general meeting or annual general meeting where the special unanimous resolution was taken. So that is also something that needs to be part of the records to prove the validity. If the rules have been approved by the members at a meeting, the trustees will sign a special unanimous resolution. If they were taken by a round robin or in writing, the members would sign a unanimous or special resolution that would be contained in the prescribed Form B that the Community Scheme Ombuds Service requires. And then, of course, very importantly, it was something that was emphasized in the Women in Sectional Title webinar today, that your scheme must be registered with the Community Scheme Ombuds Service. The Ombud will not entertain any review or approval of rules if the scheme is not registered. So very, very important to ensure that that step has been followed. We can move on to the next one. So here's an example of Form B. I know it's rather small. It's on the CSOS website. It's pretty much the same style as a trustee resolution confirming the special unanimous resolution has been taken. So that is the form that the Community Scheme Ombuds Service requires, that is signed by 2 trustees and is submitted to them along with the amended rules, unanimous or special resolution, the minutes, signed minutes of the meeting, bearing in mind that the minutes are probably only going to be approved at the next meeting, but the draft minutes need to be signed. And very often the Community Scheme Ombuds Service also requires a copy of the sectional plans. They also ask you at that time for any other documents that need to be lodged with them, and of course the registration. So this whole process could be put on hold if the scheme is not registered or compliant. We can move on from here. All right, so once these documents have all been prepared and you've got it all together, you email it to sectionaltitle@csos.org.za. They're pretty quick at acknowledging. They'll come back to you with those timelines we spoke about earlier. And if there are any questions or comments, the Community Scheme Ombuds Service, the compliance investigator that has been appointed or quality assurance officer will come back to you with those comments or questions. Depending on what it is, it might need to be referred back to the members, your special unanimous resolution, or it can simply be dealt with by the trustees. So this is something that you're going to need to keep an eye on. We do fight every now and then with the Community Scheme Ombuds Service when they do try to put through an amendment that we don't believe is suitable to the scheme. So don't simply accept it. These are your rules. The members have approved it, and you as the trustees can't deviate away from that too much. If any person asks for a copy of the rules from the body corporate, it is the CSOS approved or the deeds office registered version you need to give them, not what you have passed at the last special general meeting that happened the night before. It's only once they've been approved that they may be handed out to owners and occupiers as enforceable. And of course, that's the version that the Community Scheme Ombuds Service is going to hand out as well. If you're not sure what's on record, go and ask for it from the Community Scheme Ombud Service, go and have a look at the deeds registry if it was before 7th of October 2016, and if the CSOS does not have a copy of it, make sure that you do submit it to them. We can move on to the next one. Oopsie, there was an example of a certificate of approval. Karine, I think this was one that you shared with us. This is the latest template of the certificate. So interestingly, it used to be a hard copy certificate that needed to be collected from the head office of the Community Scheme Ombud Service. So you would have needed to send a courier. Sometimes they sent a whole bunch of certificates down to the relevant CSOS offices when they were sending a batch down. So you'd have to go and collect it. Now it is a PDF document. It is stamped and signed by the Chief Ombudsman's Office. So this is the document that will prove that your conduct rules and management rules have been reviewed and approved by the CSOS, and they're also signing, or at one point in time they were signing each page of the conduct and management rules. I personally don't like just having a certificate, because the certificate could be annexed to whatever version of conduct or management rules as the body corporate so chooses. So that's why you have all of the supporting information, the notice of the meeting, the minutes of the meeting, the submission to CSOS, to actually go and prove that the version of the rules that you're being handed a copy of is in fact the CSOS approved set of rules of the body corporate. We can move on to the next one. Who's responsible for the enforcement of the rules? We spoke about it when we first started. No point in having a lovely set of rules if there's nobody to enforce it. So ultimately, the trustees are responsible. You can have portfolios within your committee. You can delegate it to a resident. You can delegate it to a particular trustee that might live on site and might have some time, can't sleep between the hours of 2 and 4, that type of thing. You can delegate it to an on-site person like a building manager or a supervisor. You can delegate it to a company like a security company. There are some security companies that specialize in the enforcement of rules. At our body corporate, we used a company that would literally come to your door, men dressed in black, and hand the culprit a set of rules and enforce it that way. That can be quite intimidating. You can report it in your incident report or your OB logbook as security. But at the end of the day, there is no obligation on the trustees to be the police or to walk around at 2 o'clock in the morning to see if somebody is parking illegally. The managing agent can have a role to play. Perhaps they send out the notice. They warn the owner, they give advice as to the interpretation of the rules, they can assist in drafting of the rules, they will raise the fines on the levy account, and they'll give advice as to what those fining amounts would be. We spoke about the employee, a supervisor, a caretaker, that type of thing, a contractor. And then, of course, some very sophisticated systems would actually record contraventions, security cameras, access control logbooks, those type of things. And then, of course, you get your complaints via your owners. Very important to note that you can't have an anonymous tip, so you can't have an anonymous complaint. The owner that is accused of having breached a rule or the occupier is entitled to see a copy of that complaint. The complaint has to be in writing, and most rules should have a process that is set out. In my parents' older sectional title scheme, they've got a wooden post box, and they ask everybody to lodge their complaints in that physical wooden post box. They've also got a book where you can go and lodge your complaint in, and very often you see the same scribbly handwriting on every single page. So you've got that owner that complains every single 2 minutes. So it really depends scheme to scheme what that process is. I like it to go through the managing agent and to be drawn to the trustee's attention when and if it is necessary. But there must be a written complaint. It must be investigated. And of course, if it only affects owner on owner, or tenant and owner, whatever it might be, that is not an issue that the body corporate becomes a party to, because there needs to be a breach of the rules that is affecting, the general population of your scheme. So if I just hear a little bit of noise and it only upsets me, that's not necessarily going to be a breach. The rules, as I mentioned, have to be made available to everybody, and there might be the opportunity for the owners to actually have their say as to what they want in the rules. Okay, we can move on to the next one. Some of the things that the Act provides for is that the rules have to be applied equally and reasonably. So you can't say to the owner of a ground floor unit that they're allowed to keep a pet, but the owner of the top floor unit is not. You need to consider what is commercial sections or residential sections and what rules apply in those instances, and the rules need to be reasonable. As trustees, you cannot be the ultimate arbiter or the ultimate say in a scheme. The Community Scheme Ombud Service is, and of course, if an adjudication order is appealed, the High Court is. You have to apply any fines or penalties or breaches consistently. You can't allow the chairperson to get away with something and not fine them when you would allow a non-trustee to not get away with it. You can't only apply the rules when you don't like somebody, unfortunately, and not apply it to your friends. You can't give a warning to one but a fine to another. So you need to be consistent and reasonable in the application of it. Why, again, it's important that an outside person perhaps prepare and enforce that. You know, managing agent can give you some guidance and advice there. All right, the next one. Oopsie. So that second to last one deals with the fining provision. So it is very, very important that, number one, the fining rule is at the end of the document. Number two, that it does deal with the due process. The due process has to start off with a warning. The Community Scheme Ombud Service does not accept a summary fine, which we very often find in the case of parking violations. That's where your wheel clamping comes in line. You can provide for first warning, second warning, third warning, but really just one warning is sufficient. You must have the amounts of the fine in the rule or a schedule of fines, bearing in mind that the fine that is raised for any offence or subsequent offence cannot be equal to or more than a levy. The Community Scheme Ombud Service hopefully is going to clarify what they mean by that. Is it the lowest levy in the scheme? Is it the highest levy in the scheme? Is it that particular owner's levy? So we try to find a nice average there. I've been using 250, 500 and 1,000 Rand for the last 15 years. I'm sure it depends scheme to scheme and contravention to contravention. I'm not a big fan of a schedule of fines because it is possible that you're not going to cater for every single contravention. So I do believe it should be exercised in the trustee's discretion. You can have escalating fines for multiple offences. You must allow an owner or occupier to come and meet with the trustees if they wish to dispute the fine or the amount of the fine. You mustn't budget for a fine. You must be willing to reverse it or to decrease it if there is legitimate reason to do so. And if you believe that the entire process has been undertaken correctly from start to end, then of course you can go ahead with the fine. Even though there is a limit on the amount of the fine that can be raised, you can raise that limit 31 times a month or 62 times a month. Every single time there's a contravention, you could say that a fine will be raised weekly, daily, monthly, or per offence. You can describe the offences. You can get quite creative when it comes to a fining rule. But just remember, in our experience, rules aren't really enforceable unless they have that little bit of a penalty towards the end, and that is where the fining rule comes in. We don't want to live in a draconian society, of course, and we want to be reasonable, but the Community Scheme Ombud Service does give us the ability to raise fines, so I do believe that we should use it when we are able to, or at least have the threat of it. If you're not going to use it every now and then and only threaten it, it might lose its applicability, but that is in each trustee's or committee of trustees' discretion. So you would have seen that was the last of our slides. So yeah, that's it.
All right, so Linda, thanks so much. I think that was really on point and exactly the feedback that speaks to, you know, this important topic. So I mean, our officers, our portfolio teams are inundated on a daily basis with conduct that offends certain owners, that's disruptive, that's inconvenient, and that's certainly unpleasant or uncomfortable. And, you know, we need to give advice about, well, what do they do about it? How do they take it forward? So, Zelinda, can I maybe ask you, just from a point of emphasis, or to, you know, repeat in a practical way what you've said, if I'm an owner and I'm getting inconvenienced by anyone in the scheme where their behavior is contravening conduct rules that I have, etc., what should I do? How do I go about addressing that in a responsible way, in a reasonable way, but in a way that I can expect enforcement and I can expect a positive result, just assuming that the conduct is a clear breach of a clearly defined conduct rule? So maybe you can just talk us through the progressive steps. And I just think with that knowledge and that sort of, you know, foresight, it just gives owners some power, or residents some power of what they can do, what they can expect, how long it's going to take. And in some ways, it makes the disruption more manageable because they know there's a workable process unfolding, which will get to an endpoint of resolution in a particular way that they're looking for. So maybe just talk it through in a layman's terms and a practical point of view.
Okay, perfect. So one of the first things that you need to do, and you mentioned it, if there is rules in place, is that you first have to get a copy of those rules. So you might feel, in your human nature that some conduct within the scheme it must be an offense. It must be a breach of the rules. I feel so offended by that person's behavior. I feel so put out by this conduct that it has to be in breach of some type of rule. It might not necessarily be, on average, the schemes that we deal with either don't have rules, don't have registered rules, or have like a 3-page document. So it is very possible that there isn't a valid rule. So that's the first step, is to see whether or not there is a rule that is banning or regulating this conduct that you're experiencing. You also have to take a step back and think, am I being reasonable about it? Am I complaining because children are making noise at 2 o'clock in the afternoon coming back from school? Or am I complaining because somebody is making noise at 2 o'clock in the morning? You have to be reasonable about it. It needs to be something that is almost causing a disturbance or a nuisance to you, and that is a consistent breach. And then you need to first try to talk to the offender. So you need to go and knock on their door. You need to send them a WhatsApp. You need to ask for their contact details. You need to try to engage with them. And if you don't do that, it's a sign that you don't want to resolve the issue. Yes, it's difficult. And yes, very often we don't know who our neighbors are, or the neighbors might be a tenant, or in some instances, sadly, we're fearful of who that person is and the conduct that they are accused of. But that is the second step, is actually to go and try to sort it out with your fellow resident or owner. Also, to keep your ear to the ground to see whether or not it's affecting multiple owners, because if you've got support, if you've got multiple evidence, that's something that you can use as well. Follow the due process of reporting it. So if there is a process set out in writing of how this complaint needs to be addressed to the body corporate, follow that. Don't bump into your trustees in the local Pick and Pay or Woolies and say, oh, this owner next to me is constantly making a noise, do something about it. Send an email or write a letter, or, whatever the process is, go and make a complaint. Don't ask to be kept anonymous, because that complaint is part of the body corporate records, and the owner or occupier that is being complained of does have the right to that. Maybe get some evidence. I'm not saying, go around with a recorder or you'll become an amateur photographer trying to get all the offenses. There are owners that do that, but you do need to have all the information. You can't say, oh, our neighbor is constantly partying. It's this Friday at 2 o'clock in the morning for the last 30 minutes, this has been happening. As a managing agent, I remember very often getting emails where you could see the owner or the occupier was complaining at 2, 3 o'clock in the morning, because the email came through at that time with a very irate message attached to it. So, compose yourself, think about it. Is it unreasonable? Is there a rule? Put the written complaint through and follow the due process. Ask the managing agent, the trustees, how long is it going to take for this issue to be resolved? What is the steps that they're going to be following? Do you need to come to a meeting? Do you need to get evidence? Do you need to go and talk to the owner or occupier again? What was the outcome of you talking to the owner or occupier? And then, of course, follow up with the trustees if you're not hearing from them. Trustees do not need to deal with your issues on a day-to-day basis. They can keep it for their trustee meetings. Sometimes they meet quarterly, sometimes they meet monthly, sometimes they don't meet at all. So you have to think about a reasonable turnaround time, and perhaps even direct your trustees at an AGM as to what you believe is a reasonable turnaround time. If you don't have any joy there, you can attempt to meet with the trustees. You can get support, call a special general meeting. You can go to the Community Scheme Ombud Service. But in an ideal situation, if you're dealing with a complaint and you follow due process in reporting it with evidence, you should look at a turnaround time of maybe 2-3 days, maximum a week, of dealing with a complaint. The managing agent or the trustees can send a notice out, send a warning out, raise a fine if there's been multiple offences. You, as the complainant, can ask for proof that that letter's been sent, ask for a copy of it. You can ask for proof that the fine has been raised, the fine has been paid. So really stay on top of it, but don't treat the trustees or the managing agent as though they're public enemy number one. They're trying to assist you. And if they come back to say this is not something the body corporate can deal with, this is something between the two of you as owners or occupiers, you need to accept that. And if you're not happy with it, go the route of the Community Scheme Ombud Service if you feel that you've exhausted your internal remedies.
Thanks, Alinda. The other practical challenge we see often, which, you've touched on, but maybe you can just expand on a bit further, is, what should a resident do, owner or tenant, if the trustees don't take seriously the enforcement of the conduct rules? And it's often unpleasant, it's often inconvenient, it takes time, it takes energy, it does, kind of complicate neighborly relations. but nevertheless, it is the role and expectation of the trustees to enforce the conduct rules, because they're there for a reason, and they're there to promote harmonious residency in community schemes. So how should an owner or a resident, respond to trustees, not doing anything, not doing it fast enough, not responding to them? And, really I'm talking about how to prepare for an effective escalation to CSOS.
So the Community Scheme Ombuds Service does require that you prove that you've exhausted your internal remedies, but they don't set out what those are. They don't say you have to meet with the trustees 10 times, you have to send out 100 emails, and you have to have 3 SGMs. You have to do what is reasonable in your discretion to resolve this issue. So if you've got a problem with another owner or occupier and you've never met them, you've never WhatsApped them, you've never called them, you've never knocked on their door, you've never given them a letter, you haven't exhausted your internal remedies. If you have only sent one email and 20 seconds later you submit an application for dispute resolution, that's not being reasonable and exhausting your internal remedies. I would follow due process firstly. And if you don't get a response from the trustees or a suitable response, you can try to meet with them. If that's not possible, then you can start considering getting support from your fellow owners to call a special general meeting, to direct the trustees, to remove the trustees, to amend the rules, to impose fines, to direct the trustees to do that. There are solutions there. If you can't get support, or if you can get the support but you don't get the outcome that you desire at the special general meeting, you can make an application to the CSOS. You don't have to go the SGM route to go to the CSOS. If you believe you're not going to get support, you're the only complaining owner, or you're not going to get the resolution passed, or you don't believe that it is serious enough to go the SGM route, you can go directly to the CSOS. But when you go to the CSOS, you want to be confident that you've done everything you could reasonably be expected to do. A reasonable person could be expected to do to try to resolve it, and you need to put that out in your application. On the prescribed application form, there's actually a place where you're able to note. It doesn't have to be a whole LLM thesis. It can be points. I contacted, I did this, I tried to contact, I tried to arrange, here's a copy of the email, a copy of the letter, whatever it might be. And the Community Scheme Ombuds Service will then make a determination whether or not it will be something that they'll take on, if it'll go to conciliation, if it'll go straight to adjudication. Marina was talking about conciliation/arbitration proceedings, or rather adjudication proceedings in the same process. So that's something to consider for the future as well. But you just need to be confident that you've done everything possible for you. It's very difficult when you're an owner dealing with a supposed breach on behalf of your tenant. The tenant doesn't want to get involved. You might not be getting involved yourself. You might have a rental agent. You might be sitting on the other side of the world. So it does become quite difficult, and the CSOS does consider each case on its merits as to what is considered to be exhausting your internal remedies.
Great. Zelinda, just an interesting question. Somebody asked, is it not possible to standardize rules across some of the important topics that you mentioned? And maybe you could just comment on the degree to which they're consistent themes and modernized rules, and to what degree you've seen customization required at a particular property level.
Yeah. So a constitution of a homeowners association comes to mind, or a memorandum of incorporation, because that follows a very set standard. But we mentioned earlier that the template that you use is the prescribed conduct rules, although it's not a very heavy document, so it's not going to tell you a heck of a lot. But the practice directives, as we are now 6 years down the line from the Sectional Title Schemes Management Act coming in, is quite comprehensive, telling us what types of rules we can't have and what types of rules we should have. So simply taking the prescribed rules and the practice directives, that already would give you a standardized or template-based set of rules. But every scheme is different. The problems that they experience might, overlap, but every scheme is different. Every scheme is unique because they're dealing with people, and every person is different. So it is dangerous to have an idea of having a template across the board. There have been discussions with the Community Scheme Ombuds Service in putting together a standardized set of rules. I don't think it's a good idea. You have a duet scheme, you've got a multi-layered scheme, you've got a mixed-use scheme, you've got residential, commercial. Everything is going to be different. But with the prescribed rules, with the practice directives, that will give you a very good base to start off with, and some schemes can simply have that. But yeah, there isn't such a thing as a standardized set of rules. I don't think that it's a good idea either, but there's a lot of rules that should be in a document that would be the same or similar throughout the different schemes.
Okay, good. Thanks, Linda. An important question about POPIA, the protection of personal information, and it's to what extent, if there is a complainant about a particular conduct to the trustees, how do the trustees fully investigate and fully respond to the complainant or the person alleged to be breaching the conduct rules without disclosing personal information?
Okay. So there's a lot of different opinions about POPI. Now, the Sectional Title Schemes Management Act, under the regulations, the management rules provide that any owner is entitled to the records of the body corporate, including the complaints, the contact details of owners, to engage with each other, who that complainant is. So that information is available to an owner or person authorized in writing by an owner. But any person that is requesting that has to have a good reason, a lawful purpose, the POPI legislation speaks about. And if it has to do with the administration or management of the scheme, if it's got to do with the valid complaints, if it's got to do with the attempts at dispute resolution, that would be a lawful purpose, and that information should be disclosed. If you're going to, take the name and ID number of the complaining owner and put a fine on their account because you're good at hacking computers or you work for the traffic department, that's not a lawful offense. If you're going to play a prank on them and try to sell their unit, that's not a lawful reason there. So we have to be reasonable and undertake this in a lawful purpose. But it is possible to make that information available. It is possible for the trustees to investigate. But again, the trustees are not going to investigate a complaint between owner and owner or occupier and occupier if it only involves them. It has to be something that affects the scheme. Generally, it needs to be a proper breach of the rules. There needs to be a warning before any of that investigation comes in. And of course, a legitimate written complaint with evidence.
Good. And maybe just to complete the earlier questions, Linda, what would an owner do if the CSOS ruling in their favor is not acted upon?
If the CSOS ruling in their favor is not acted upon. Okay,
Yes.
So if there has been a CSOS adjudication in your favor, it normally is going to set out a timeline. I actually saw one today where a special general meeting had to be called 30 days after the CSOS order was handed down. And if that meeting was not called within 30 days, either one of the parties are able to make that order enforceable through court. You have to approach the Community Scheme Ombuds Service and they will certify the order. You will then either go to the Magistrates Court or the High Court, depending on the relevant jurisdiction. You'll go to the Clerk of the Court at the Magistrates Court or the Registrar of the High Court, and you will have that CSOS order issued as a court order, and then that will be able to be served and filed and all those fun things. And if there's a breach of that, then obviously there's a lot more consequences that come into play. The compliance units of the Community Scheme Ombuds Service is also becoming quite active in regards to enforcement of orders, compliance with the CSOS legislation, compliance with orders. So you are able to lodge complaints with them as well, but you are able to take the next step when someone does not follow a CSOS order. A CSOS order, once it's handed down, is final and binding. It can only be reviewed or appealed on an error of law. With the internal review process that is going to be introduced by the practice directive of the Community Scheme Ombuds Service, there's another step to engage positively in that regard. But the CSOS order is not pended until the next step is taken to try to dispute it. It still has to be acted upon. It still needs to be complied with. But court would be the next route to do that, unless you are dealing with the complaints or the compliance units of the CSOS.
Thanks. And so, Linda, just as a reminder, can a fine be imposed without a first warning?
So summary fines, which are the fines that are raised without a notice or without a warning, is not allowed by the Community Scheme Ombuds Service. So you do have to have a warning. Now, whether or not a sign is going to be a warning or a notice to all of the owners reminding them about it is going to be a warning, that's subject to what your rules say, but you do have to follow due process. I always like to first actually issue that offender an actual warning that says, on this day, at this time, you breach this rule, this is the consequence. And if they breach it again, we go ahead with the fine because now they have been warned, or you engage with them if they believe that they shouldn't have been warned. But each scheme and each breach is very much going to need to be taken into consideration to see how you're going to deal with it. I think parking is one of the few ones that I think that a summary fine is justified, because if you're parking on somebody's parking bay right now, they want it sorted out right now. They don't want you to first be warned that you can't park there in the future, but there are other solutions.
So Linda, why don't you just comment quickly on a round robin resolution and what documentation pack would be submitted to CSOS for approving updated rules based on round robin resolutions?
Okay, so it's not very often that a special unanimous resolution gets taken via round robin because of the elevated voting needs there. So if you take a special resolution via round robin, you need 75% of all of the owners as opposed to 75% of a quorum at a meeting. If you're taking unanimous resolution by round robin or in writing, you need 100% of 100% of the owners as opposed to 100% of the 80% quorum. You would need actual written approval, so electronic signatures, handwritten signatures, confirmation that it is a particular owner. You obviously won't have a proxy because there isn't a meeting. You could have an authorized person that is signing if there's co-owners or a power of attorney or a CC, a company, a trust, a partnership, that type of thing as the owner. So all of those emails or hard copy document or electronic signatures submitted on a document, whatever form that round robin has taken, would need to be submitted to the Community Scheme Ombud Service. As well as the Form B, and then of course notice to the CSOS that the notice went out correctly, because even with a round robin resolution, you still have to give proper notice to the resolution, and you would then just confirm that you wouldn't be able to submit minutes of a meeting because you didn't actually have a meeting. It was via round robin. I've only had 1 or 2 experiences where I've needed to submit something like that to the Community Scheme Ombud Service, because as you can imagine, it's incredibly difficult to get that high level of consent via round robin resolution. But I have had them come back to say, please give us the minutes of the meeting. So you need to just explain that, there won't be minutes because it's via round robin or in writing. You can't only go to 75% of the owners until you get those signatures and ignore everybody else. Everybody has to be notified. Everybody has to have an opportunity to cast their votes. And of course, with unanimous resolution, you just need, in the case of a round robin, 1 owner to not sign or not approve, and unfortunately it won't pass. You can make an application to the CSOS under Section 6(9) of the Sectional Title Schemes Management Act, noting that a special unanimous resolution has failed because of unreasonable objection, or you can make an application under Section 39 of the CSOS Act to deal with the fact that a motion was not passed because the objection to it was unreasonable. So it depends which route you're wanting to go. For the first route, in terms of Section 6(9), you must have proof that you've at least obtained 50% for a special resolution, either at a meeting or via round robin. And for unanimous resolution, you have to get the quorum, or you need to get at least 75% of that quorum to vote in favor of unanimous resolution before the CSOS will even entertain it.
Yeah. Interesting question here is, these rules are obviously enforceable in the specific scheme concerned. It doesn't really help with a neighboring complex where there's a breach. So that would need to be escalated or addressed via the bylaws and SAPS, for example. Is that right, Celine?
Exactly. It's so interesting that you mentioned that. My colleague Nicole now was actually in correspondence with CSOS as recently as last week, where there was a dispute between 2 neighboring body corporates, and the CSOS said they're not going to take that matter on. So that's quite interesting to see that they're not going to deal with that, because it's, like you said, 2 neighboring properties, and the court would need to deal with that in terms of neighbor law or common law.
Yeah. And I mean, just to confirm as well, a scheme would need to be registered with CSOS first to be able to approve conduct rules. So the one comes first. It would not be possible to, register and get approved conduct rule certificates without the scheme first being registered and paying their CSOS levies to the CSOS Ombud. 100%. Yeah. We're running out of time. Maybe an interesting question, Zelinda. Somebody's asked, what are the rules around smoking marijuana in complexes?
I was hoping you were going to ask me that one. So interestingly, we've got case law, constitutional case law that deals with this. We very often put it into our rules, and most of the times, actually, the trustees are like, no, we can't allow that at all. You do actually have a right to consume legalized marijuana within your section or your exclusive use area, but not on common property. So again, very important to know whether or not you do in fact have a legal exclusive use area, because you would not only be breaching the rules of the body corporate, but the rules of the country if you are smoking on common property. So no joints can be smoked at the swimming pool or anything along those lines. And of course, if you're going to be cultivating it, it needs to be for your own personal consumption. There's a lot of interesting theories and things about that. But, at the end of the day, the laws relating to nuisance and common laws also going to apply if somebody gets irritated by your cigarette smoke or your vaping smoke or whatever it might be, they might get irritated with the marijuana as well. We always joke to say that the outcome of it is going to be a lot more pleasant than cigarette smoke, but it is most certainly regulated. And I think if you don't want to experience that within your unit, don't force anybody else to have to experience that. But you are allowed to consume it within your section or exclusive use area, bearing in mind that you have to use it reasonably. Balconies, exclusive use areas are going to be open. They are going to affect other people. The same would apply with smoking, use of braais, that type of thing.
Great. Okay, everybody. Well, thank you so much. We are out of time. So on the screen, you see contact details. You're very welcome to make contact with any one of us. We'll endeavor to answer any questions that may come up. Karine and I did answer around about 120 questions, but there are a few that we didn't quite get to, so I'm sorry for that. But you're more than welcome to come back to us. I have recorded all of you that have asked for the slides, that have asked for the Q&A. So I will send you the slides in PDF form tomorrow. Zelinda, I'm sure you won't mind me packaging them and sending them off and circulating them, as well as the Q&A from Zoom. So I'll gladly do that tomorrow. And then a reminder that we will post the recording of this webinar on that training.trafalgar.coza website latest by Wednesday. So have a look then. And then there are a number of other topical and useful webinars recorded there. So in closing, Zelinda, thank you very much indeed for attending, for the very interesting and relevant presentation. Karine, thank you to you. Thank you everyone for participating in your time, and we wish you a good evening. Thank you
So much. Bye-bye.